2, 1. And we are live. Good morning, good afternoon, good day. Depends on what time and where you are in the world. My name is Clara Lyons-DeVaughn. I am the broker owner of Lyonsview Realty. Our team provides residential, commercial for small businesses and nonprofits, and property management services. So I'm excited to introduce coming soon will be Lyonsview Academy, where we will be providing real estate pre-licensing courses, continuing education. We also do credit counseling and distressed home owner solutions. So Lyonsview Realty launched Financial Fridays to help you stay current on trends that impact your bottom line. Our goal is to provide you with resources, information, tips, those things that assist you in making the best financial decisions. Our commitment is to maximize your wealth building power now and in the future. So I'm glad you tuned in today. Welcome, welcome, welcome. Feel free to like and share this video. Our guests are really here as a resource to you, so please feel free to ask questions. You can type those in the comment section below, and we'll go from there. So as you know, June is Home Ownership Month. And during this month, we've been kind of stepping you through the path to home ownership, that process. We've talked about debt. We've talked about savings. We've talked about credit. We've talked about the loan process and how you prepare for that. And today, the next step in the process is title. And I'm very, very excited to introduce you to a gentleman that I've known for a few years now. He is a member of the National Association of Real Estate Brokers. That's how we met. He's not a real estate broker, but he's a real estate professional in the industry. And that's one of the things that you should know. You don't have to be an agent or a sales agent or a broker, real estate agent or broker to be a member of the organization. You can be in title, as our next guest is. You can be a home inspector. You can be someone interested in the process, but we're really about democracy and housing. So Mr. Richard Ransom is the president and CEO of Collegiate Title. And I'm just so, so excited to have you with us today. Welcome, welcome, welcome.
Thank you, Clara. Thank you for having me here on your podcast today. Welcome, everyone. As I was telling Clara that I'm not a public speaker, I'm a title guy. So most of the time, I'm either in closings, searching titles, or in the courthouse, searching records in the dungeons, so we call it. But your title is the last part of the transaction of buying a home.
Tell us a little bit about you before you. Yeah, a little bit about you. Yes.
Okay. I opened up Collegiate Title in 1995. We are celebrating our 25th year in providing title services. We are here in New Jersey. We have an office in Morristown and also one in Island, which is exit 131 off the Garden State Parkway. So we service both North Jersey and South Jersey. So we make sure that we are satisfying all the customer needs. Prior to going to title, I was a group vice president for Mid-Atlantic Bank. I was responsible for the branches that were in Camden County and also in Philadelphia. So I'm not a new guy on the block. I've been around for a while. Prior to getting into banking, I was an educator. When I first got out of college, I was in education. So I've always focused on giving back to the community. And title is a way of also giving back and serving community, because we are our communities are drastically underserved, and a lot of people don't understand the concept and the not requirement, but how good it is to beneficial it is to own property. So that's my overview. Now,
indeed,
huh?
I said indeed.
Okay.
Indeed. A really great point. And I know your time is extremely valuable because deals are closing and I know you have stuff to do, but what is like the simple definition of title?
Simple definition of title. Title assurance is that the seller is conveying marketable title to the buyer. Marketable title means that it's free and clear of any liens or defects or encumbrances on it. Now, saleable title, yeah, well, saleable title means that somebody will be able to buy it. Yeah, you can buy title, but you want to make sure it's marketable, meaning that on an open market, it's free and clear. It doesn't have any liens, doesn't have any encumbrances on it, that it's in a fee simple state. Fee simple meaning that there are no other items against it. No one else has a claim against the property or the property that they're conveying, and that they are the owners of the property. Now, why is that important? Because a lot of times that we may see that a party, when I say a party, it doesn't have to be a person, can be a state, it can be a corporation, it can be an LLC, will try to convey a property, and they are not the owners of the property. They're not the rightful owners of the property. We have seen times where a family may have the mother and father have died and left the property to the children, and one of the children will try to sell the property without the consent of the other siblings. So we are making sure that the seller has the absolute right, the legal right to convey the property to the buyer. That's free and clear of any liens. Now, you say, in that being said, we offer or we provide two different type of title policies. One is going to be a lender policy. One is going to be your owner's policy. If you are getting a mortgage from the lender, they are going to require that you obtain a lender's policy to ensure them that there are no other entities in front of them and they have first lien position against the property. So when they give you the mortgage, and the mortgage is recorded in the county, they are in first lien position, that no one else is in front of them. New Jersey is a race state, which means that the first one who records is the one that has the best priority on the property. So the lender wants to make sure that they are in first lien priority. The second one is the owner's policy, which ensures the owner to the property. The buyer pays for both the lender's policy and the owner's policy. Okay. Now, when we are searching, we search a couple of different ways. We are searching the county level and the state.
Let me back up for a minute before you go there. So what happens? The buyer, the seller puts the property on the market for sale. The seller come to agreement. They have an executed contract. Once they get that executed contract, the very first thing that the buyer wants to do is open title. So they would come to see Mr. Ransom at Collegiate Title and say, look, I'm getting ready to buy this property. I want to make sure that it is free, clear from encumbrance. What did you say? You want to be able to convey it without encumbrances, liens, or anything against the property. You want to have clear title. And so now he says, okay, and he starts the process of what we call a title search. Correct? Is that what you're getting ready to explain?
That is correct. We start the title process of searching the property to see what is against the property. So that's the title search. And Clara used something which I haven't heard in a while: open title. So yeah, order title, open title. Yeah, it's open title. And in North Jersey, down here we say title commitments is the document that we provide to all parties of the condition of the property. We call it title commitments down here. Up in North Jersey, they call it binders. So it's two different ways in North Jersey and South Jersey. And even though we are in New Jersey, it's two different states, the way that we do title. So yes, now let's get into.
You brought up a good point. New Jersey is a different state altogether, because New Jersey, Pennsylvania, Delaware are all lien theory states, because there are people watching this in other states across the nation. But where we are, people get legal title to the property. And so the mortgage loan is basically a lien against the property. But, if the borrower were to default, they would have to go through a judicial process to foreclose on the property. So we're a lien theory state, and people actually have legal title to the property. So talk about a little bit the difference between legal title and equitable title, because
Okay,
we're addressing people in both states, both types of states. Yeah.
back up a little bit. Yes, in New Jersey, we are a judicial state. However, federal government takes precedence over everything else.
Okay.
So, are there any type of products that a foreclosure would happen with a non-traditional foreclosure? Most people will say no, but yes, there are. Reverse mortgages are something which is governed by the United States. Okay, so it's a national type of product. They are the only type of product that goes through foreclosure, which is a non-traditional transaction. It doesn't go through the court system for foreclosure. That's the only one, which is very unusual, and a lot of companies do not insure this type of transaction. But that is one that doesn't go through the court system for foreclosure. So that's a unique thing. Clara and I both Clara is from California. I spent a lot of time in California because my parents moved to California when I got out of college. So California does something altogether different than how we do it here. We do title kind of like backwards as far as how California does it. They take everything in escrow, and they do everything in escrow. And then after it goes through escrow is closed, then they convey ownership. Well, we don't do it that way here. We do it a little differently, but that's another conversation, Claire, that we can go through. But yeah, that's the difference that we have as far as the ownership or different types of title. Yeah, most time it is judicial, but there is one type of product with a reverse mortgage. And is anybody familiar, Claire, with what a reverse mortgage is and why?
We actually did an entire show, an entire podcast on reverse mortgages. So I invite people to look at that particular podcast to get the details on what reverse mortgages, what they do, how they work. Yeah, so we did cover.
Okay,
but that was good information because I didn't know that it's a non-judicial foreclosure in the state of New Jersey for reverse mortgages. It's the only what do you call it? Exception.
Only exception, and it's very unique. A lot of title companies don't get involved with it. We do, but it's under strict guidance and direction of our underwriter, and we have to make sure that all the proofs have been properly executed by the foreclosing attorneys. Everyone has been properly served. We have evidence of all that, and then we will make a determination if we're going to insure that transaction for resale. So it's unique. It's something which is out of the ordinary, and it's on a case-by-case basis. I had one attorney that asked me yesterday, said, well, okay, we know that you insure them, so guarantee me that you will insure this transaction. Well, I can't guarantee it. I got to look and make at the search material and make sure that everything has been properly executed before I will insure that transaction. So it's a one-off. It's very unique, but we do them. Okay? Now, I was going to say, as far as what we search for, we have to make sure, and when we're doing our searches, that there is a properly recorded deed on the property, that the seller is entitled or is in ownership of the property. That we look at the last recorded deed that is of record. Now, some people say, well, I have a deed, but it's not recorded. Like I said before, New Jersey is a rare state where that the one who recorded is the one who's on record. So we have to make sure that there is a deed of record on there. Or someone may say that my mother and father died, and we have a deed here that changed the ownership to me, but they died before. Well, that's too bad, because we go by what's there, what is of record. When somebody dies, okay, then you have to go to the circuits office. We're going to talk about that a little bit to see if somebody died intestate or testate. And if they died one way, intestate, one thing happens. They died intestate, another thing happens. All right. We make sure that they're
intestate is with a will or without a will.
If somebody dies testate, they died with a will. They die intestate is without a will. Testate with, intestate without. Okay. Yeah. Did you go over that yet in your classes, or did you have an attorney come in and go over estate?
No, we haven't had an attorney. We will. Yes. Thank you. I said no. We haven't had an attorney come in yet, but we will.
Okay. Circuit.
So you're talking about Mm-hmm.
Say again.
Oh
Circuits
no, you
office.
were talking. Go ahead. Is there a
Circuit.
delay?
Yeah, a little bit. A little bit.
Okay. Okay.
This is all new to me, so hey, I'm old school. So give me circuits office, and states that's unique, and I know Claire will go over that in a different podcast. But like I said, we searched it for deeds of record, what's there, who shows the ownership, and who we will look to as far as conveying the title. We look for judgments against the seller. Now, deeds will show us, and mortgage are recorded. Mortgages are recorded with the county. We also do something which is called a judgment search against the sellers. Judgment searches are something where we run a special report, and it shows judgments which are against the sellers that are not of record or recorded with the county. So if you have a child support, if you have a judgment that was filed with that was went to the court, and the court said yes, you have a good judgment against this person, and it's going to turn into a lien, that we see it when we do a judgment search. Judgment searches are all that have to be addressed before we can convey the property. Years ago, child support we could escrow for, and we could say, okay, we're going to hold $5,000 in escrow against the seller so they can get their issue addressed for child support. That doesn't happen now. Child support has to be addressed prior to closing. If they have open child support, they have to pay it off or have some type of decision from the sheriff's office as far as child support. You just can't gloss over child support any longer. Child support is a very important thing. We look for less pendants. Less pendants is something that there's a legal action going against the property, that we make sure that there's nobody filing a foreclosure action, because then we have to stop and see what's going on with that. We also
I
look.
had one of those yesterday. I had one of those. Well, yeah, actually, it came up last week when they did. The search came up, and it was like, oh my God, there's an impending, foreclosure on this property. So they
Yes,
had to address that. Yeah.
yes, and for just that reason, that's why they filed the less pendants, so everybody to know to pause and say, stop. There's something legally going on with this property as far as a foreclosure action has been filed. So that gives us notice that we have to look for other things. Notice of settlements. That is filed by a title company to let everyone know that we are going to close on this property. Why is that important? That's important so that a person will not try to sell a property twice or three times. That has happened. That has happened. A person, sports person, very well-known person, tried to sell properties 2 or 3 times, the same property. Wow. And the only way that they were stopped or found out about it, because notice of settlement was filed. And if a notice of settlement is filed, then the title company who is filing or closing, and it was filed by somebody else, they had to get that notice of settlement released. Wow. All right. Okay. We talked about institutional liens. If somebody goes into a hospital, that has to be addressed because that's a lien against the property. Builders, if you have a stop notice or a mechanic's liens, they have to be addressed. So we don't want anything against the property so that it may be a detriment to the buyer. Surrogate's office. We talked about somebody died and they died intestate without a will. They had to go to the surrogate's office. They had to file the proper documentation with the surrogate's office, death certificate and whatever, and showing that the person's died, and they want to have the right and the ability to sell the property. The surrogate's office will require certain documentation from them. They will ask who are the next of kin. They will ask who's going to renunciate themselves. If it's 2 or 3 different siblings, every sibling has the right to be an administrator of the estate. And if there's not going to be co-administrators, mean more than one, then the other 2 or 3 who are eligible to be administrators have to renunciate themselves. Okay. One thing about a administrator or they cannot have that authority given to somebody else. So somebody who's an administrator can't say, well, I'm going to have a power of attorney signed for me. It can't happen. Administrator cannot give that power, their executive power, to somebody else. All right. It must be either another administrator or somebody else. It cannot be given away to a power of attorney. Okay.
Okay.
Any questions so far on that, Claire? That was good.
So the administrator, yes, is the administrator appointed by the court, or the administrator is just the family gets together and decides who's going to be the administrator?
Well, the family gets together and before themselves and say who's going to go to the circuit's office and who's going to apply for the letters of administration with the circuit's office. The circuit office is going to appoint who is going to be the administrator for the estate. Okay. Now, administrator is for someone when they don't have a will, and executor or executrix is for somebody when they do have a will, and the will is probated with the circuit's office, and they will give letters testamentary to that executor or executrix, allowing them to act on the behalf of the estate and do the matters or the business of the estate. Okay.
So when for title, all of this will come up, who that person is, or
who that is,
right? All that information about who has the legal authority to be involved in conveying the property.
Convey the property, yes. And we need to have that, or we can't move forward if it's coming from an estate.
Gotcha. That's a range of different types of liens against the property. I mean, it's quite an extensive list. Are there other things that might pop up on a lien, or other things that might cloud title, as we say?
Yes. Also, there could be liens for open water and sewer. They have to be addressed. That's municipal liens. If there's a tax sale, if someone didn't pay their taxes, the municipality has the right to hold a tax sale, and a third party, can buy that tax sale and hold that, and they will pay continuing taxes for the quarters until that property is sold. Or after 2 years, they can foreclose on that property and take ownership of that property. So that's also important. Now, all these things that we have spoke about are important because they are liens against the property. And we are identifying what is against the property so that the buyer will not have anything against them when they take ownership of the property. All right. If a corporation is in the ownership of the property, they have to file a bulk sales form with the state of New Jersey to make sure that there are no open taxes due to the state of New Jersey. If there are usury taxes or sales taxes, the state of New Jersey will say you can convey the property. However, you have to hold $10,000, $20,000 from the seller's side before it can be conveyed. Now, if a bulk sale request is not done by the buyer prior to closing, the debt of that bulk sale, which is exposure that is due from the seller, now becomes a debt of the buyer. So that's why the buyer side is the one who does the bulk sale request with the state of New Jersey. Okay. Federal tax liens also have to be addressed. State liens for unemployment have to be addressed. All those things are done, and we make sure that they are addressed prior to closing. If there is a divorce decree, a divorce settlement, we got to have that, because sometimes the divorce settlement would say that the property has to be conveyed to one party or the other. We have had situations where the court will say, okay, the husband has to sign over the property to the wife, or vice versa, and it's never done. The husband refuses to do it, or the wife refuses to convey the property. They have to go back to court. the court will give the party whose rightful it should have been given to a power of attorney to sign the documentation on the behalf of that person who refuses to sign, so that it can be conveyed. We have had that happen also. Okay.
So you definitely earn your money. That's quite a bit of things that you search for. So after the title company goes out, looks for all of these different things, is that when the title report is generated?
Yes. What we do once we get all our searches back, we will put our findings into a title commitment, which is a abstract or synopsis of the condition of the property. Who do we find? Who are the owners of the property? A history of how they obtained ownership of the property. Then it will also identify who has to convey the property, what has to be done by the sellers to convey the property, and anything what has to be done prior to, and that has to be satisfied before we can go to closing. And that's called a title commitment. All parties will receive the title commitment. Now, buyers, one thing I want to go over is types of ownership. When you are buying the property, there are a couple different ways that, well, more than a couple, there are 3 or 4 different ways that you can acquire the property. If you can buy by yourself, which is sole ownership, the deed from the seller. Now, the seller is the one who prepares the deed for the buyer. You tell the selling side how you want it, or your realtor will convey to the selling side how they want that deed to be conveyed. If it's by yourself, you're buying it by yourself, they will say it's going to be in the name of Clara Lyons, a single person, or sole ownership. If it's going to be in husband and wife, they're taking ownership as husband and wife, it will be called tenants in entireties. It will say Mary Smith, John Smith, husband and wife. And it shows that that they're taking in tenants in entireties, meaning that neither party can alienate that property without the consent of the other person. Wife cannot sell the property without the husband.
Alienate means they can't sell it.
They can't sell it. they can't sell the property without. I'm sorry. They cannot sell the property without the consent of the other party. We had that happen. We had someone to come to the closing, and it was man and woman presented themselves as the sellers. They were talking to each other. They were laughing, giggling, smiling, talking, whispering to each other. So when it came for them to produce all their ID, they said to us, "Well, we left our ID in the car." They left the office, never came back. Here it was the husband and the husband's girlfriend trying to sell the marital residence without the wife's consent. So it does happen. It does happen. All right. If you buying the property as joint tenants is another way you could do it. Joint tenants with the right of survivorship. That means that you're buying a property with another person. When somebody dies, that property goes to the other owner of that property. All right? It goes to the other owner of that property. That's called joint tenants with right of survivorship.
Right of survivorship. Gotcha.
Yes.
Okay.
If they buy it as tenants in common, 2 people buy as tenants in common, one party dies, their right or their ownership interest of the person who dies does not automatically go to the other owner of the property. It goes to the heirs of the person who died. Am I making myself clear? 2 people buy a property. One dies, instead of going to the other owner, no. The person who dies, their interest to that property goes to the heirs. So now,
okay. So let me
go ahead.
Let me see if I got it. So, tenants in common would be like you and I. We bought a property together. Something happens to me. It goes to my heirs. My rights in that property go to my heirs. Tenants in joint tenancy with right of survivorship we have together. If I die, you get the property. Uh, tenants in its entirety, husband and wife, we're married. You can't sell without me, and I can't sell without you.
Right.
And
And
then
when
other sole ownership means I own it all by myself.
you're all by yourself, you can do anything with it at any time that you want to, at
Yes,
any
got
time.
it.
Okay.
Got it. Thank you.
Now, also, you had the Domestic Partnership Act, which is
Oh,
almost like the tenants in authorities, where
that's
they're
new.
called civil unions. They came about in 2004, was adopted January 12th, 2004, the state of New Jersey, and gives legal recognition to civil unions between same-sex couples. It provides the same rights and benefits enjoyed by marital heterosexual couples enjoy. That came back in 2004. All right. But buyers, make sure that you identify with your agent, with Clara, how you want the deed to be recited when you are taking ownership of the property. Because if you don't, if you're buying it two people and you don't identify there's going to be joint tenants with right of a survivorship, it's going to be tenants in common.
That's the default.
That's the default. That's the default.
Gotcha.
Now, surveys. I'm not going to go to a lot of detail about surveys. Surveys are something which identifies the boundaries of the property, the meets and bounds of the property. You may want to have a survey done if you are putting up a fence, or if you have a large lot or even a small lot, you want to know where the boundary lines are. All right. Most times, if you're buying a pre-existing property, that property has already been shot, has already been identified with meets and bounds stakes. Those monuments are in the ground. Monuments are concrete monuments that have a metal plate or a metal rod inside. And when you see a surveyor go out, they go out with a metal detector and they identify where the boundary lines are. Right? They are in the ground. They're in the ground, maybe about a foot or 2 feet down in the ground, and they are permanent markers. So if a surveyor says to you, "Do you want us to set the corners?" That's the term they use, set the corners. Well, you would say to that surveyor, "Well, only set them if they haven't already been set. Try to find the markers that have been there already, and they will go out and look for the monuments." All right, because you don't want to pay an extra $500-$600 to set monuments if they're already there.
Exactly.
Important.
Oh, I just had a question. So, once a survey is done on a property, is that recorded? Like, does it come up already? So, like, would the title company know that monuments already exist for that property? Is that something that gets recorded over time, or?
The only way we can tell if it's there already by a pre-existing survey will show that the monuments are already there. Okay. Why are monuments or important, or boundary lines important? Because people sometimes, for some reason, forget where their property lines are, and they will start cutting their grass more and more on your property. And so when you buy the property, you don't know where the boundary lines are. And they're going to say to you, "Oh, no, Mr. Smith, this is my property because I have cut this grass for 20 years. It's always been over there by the oak tree." Well, maybe not. Maybe it's your property over there by the oak tree. So you want to make sure where your monuments are. Okay? In Willingboro, as one of the towns which is in South Jersey, that you must have a survey given to the township for them to provide you with a CO, because they want to make sure that your boundary lines are where they're supposed to be. Now that goes into a different thing as far as COs and inspections, but we're not going to that right now. But that's important. Okay.
Yeah. I guess we should say about that is that it varies from township to township. So depending on where you're purchasing, the property will determine, what you have to do in terms of certificate of occupancy. Even sometimes things like termite reports, that's with the lender. So there are other things that aren't title specific, like title doesn't say you have to do this. It's basically the township or the lender that will require certain things to be done or not done.
Yes and no. When I say yes and no, when I only say that because title, yes, cannot dictate that you do not have a CO, but if a CO is required by the municipality, then title has exposure if we allow that property to be conveyed without the proper CO or proper inspections. In New Jersey, you must have a smoke detector, fire extinguisher, and carbon monoxide on all properties. And the township will come out and make sure that they are there. Unless it's a shell, then they give you a conditional CO or whatever. Does a title company require you to have it? That's a big question, because we have had instances where we have had exposure because someone would say the title company allowed us to convey this property knowing that the CO wasn't there. So therefore, they knowingly let us convey that property. They have exposure. We had one property where a CO was not done because the buyer and seller said, oh, okay, we take care of it later. They signed an indemn about that. When they went to the property, the buyers to look at it after closing, they left the porch light on. The house burnt down because there was a bird's nest next to the light on the porch. The light was left on overnight. The bird nest caught fire. It burnt the house down. Wow. So yes, there is exposure. So yeah, I am a very conservative type of title company. I do not deviate from the rules. If there's a CO required, I'm going to press upon everyone to get the CO. If they don't want to get a CO, I'm going to do everything in my power not to close that. And if they still insist, then I'm going to have the attorneys draw up a indemnification or hold harmless to hold us harmless if something happens. Because the CO is for your benefit, buyers, to make sure that property is inhabitable. That's for your benefit. You want to have that. Okay?
How long does a survey take typically to get one? Like, how much lead time do you need prior to closing to order a survey if the buyer wants it?
We like to, once you know that a survey needs to be ordered, please order it right away. Normally it takes 5 to 7 days for a survey to come back to us or to you with the boundary descriptions. But that's something that you should do fairly right away to get that back in, because a lot of times the lender will want that part of their closing requirements to see the survey requirements. So that wants to be satisfied. So you should do it right away. Okay. One thing also at closing, you're going to get something which is called a closing disclosure statement. Closing disclosure statement is a document with all the cost. Your cost as far as what it's costing you to get the money from the lender, what they charge you for points, what they charge you for reserves, what they're charging you for to do the loan. There's going to be title cost on there. There's going to be cost for escrows on the CD. There's going to be our cost as far as the searches, settlement costs are going to be on there. It's going to be anything else that involves the survey is going to be on there. Any cost that is going to be associated with this transaction is going to be on the closing CD. That is given to you 3 to 5 days before closing. However, the lender is going to give you an estimate when you first do your application, which is pretty spot on what you're going to be have to do for closing. So people say, well, I don't know how much. Well, the CD is produced by the lender. 2 years ago, before CFPB, the title company prepared the HUD-1 settlement statement. When they changed over, it went from HUD-1s to CDs. Now the CD is prepared by the lender. The lender is the one who prepares the CDs, not the title company. They give it to us. We review it, add anything that we had to add to it, give it back to the lender. The lender is the one who has the final CD for closing, not the title company. Okay.
Yeah, CD is a closing disclosure.
Closing disclosure.
Closing disclosure. So it just discloses everything that you're agreeing to for your loan, or if you're doing a cash deal, all the charges that you're being charged in order to do this transaction that we call title. Yeah.
Right. Now, Clara mentioned about cash deal. If it is a mortgage transaction, there's going to be a closing disclosure. If it's going to be a cash deal or a commercial deal, it's going to be a HUD-1.
HUD-1.
All right. They are the difference. HUD-1 settlement statements for commercial and for cash deals, closing disclosure for a mortgage transaction. Okay. The lender's going to give it to you 3 to 5 days before closing so that you can have a chance to review it with your attorney or whoever else you want to review it with, to make sure everything is accurately on the closing disclosure. There's one for you and there's one for the seller. They are not together. Now, it's something called an alter, what may be combined, which is it shows both the seller and the buyer side together. But the actual closing disclosure, there's one for you, one for the seller, because they want to have it for privacy reasons. There's no reason for the seller to have your information. There's no reason for you to have the seller's information, according to CFPB.
This is great because I'm cleaning up my language. So I have learned that it's a title commitment, or binder if I'm in North Jersey instead of open title.
Right.
I've learned that there is a new category of how you can hold title for same-sex couples who
That's
are
the Partnership Act. Yes.
Partnership Act. Do they have to be married? Are they married same-sex?
Do they have to be married? Not.
Or they can.
I hesitate to answer that question because I think they would have to be some type of civil union, and not the word married. It's called civil union.
Okay, so that would entitle them to the entirety.
Right. Yeah.
Gotcha.
Yeah.
Okay.
So it's wording, and it's civil union than marriage.
Gotcha. So I learned that the HUD is for cash deals and commercial deals. The ALTA shows both sides, and that the CD, or the closing disclosure, there's one for the buyer, one for the seller, and the buyer one has all the buyer's information. The seller closing disclosure has all of the seller's information, and they are separate.
They are separate.
For
now,
privacy
reasons. Buyers, we're getting to the actual closing now. And one thing, we're going to combine the information about the CD and the closing. At closing, because you had that CD prepared by the lender 3 to 5 days before the settlement, that cannot be changed at the table. There used to be a time when you go to the table or the closing, we call it the table, another jargon for the industry. You go to the table. Well, that's the closing. When you sit around the table for everybody there, you go to the table and signing documents. That cannot be changed. Now, when I say cannot be changed, if you want to go through the transaction that date, on that day, you cannot change anything on that lender's CD or that closing disclosure. If something has to be changed, a lot of times it has to be redisclosed by the lender, meaning that the closing will not happen that day. It will go back to the lender. They will re-underwrite it and set a new closing date. Okay? So if you have an issue with something, it has to be disclosed to the lender prior to closing. Right? Prior to the settlement table. Because you can't change it at the table any longer. Can't be done.
Right.
Now, we talk about settlement, the closing table, whatever. It's a formal meeting of the parties. We don't. I never like to bring the sellers and closing together even prior to COVID-19. Now we do not put the closers and the sellers together, the buyers and sellers together at all. They are separate. They're kept in separate rooms or out of the office altogether. We go over the documents with the buyer at the closing, what means we sign all of the documents from the lender. What's going to be the note, the mortgage, any affidavits, signature affidavit. It could be anywhere from 85, 90 pages to 150 pages, what the closing package will be. At the closing table or at settlement, now many times the lender will require us to email or scan to them a lot of those documents so that they can review it and make sure it's signed properly, correctly, and dated properly. If your name is Richard Ransom Jr. and you took application as Richard Ransom Jr., the documents are going to say Richard Ransom Jr. and you just can't sign it R Ransom or R Jr. You got to sign your whole name. However you made your application is how those documents are going to come out and how you have to sign those documents. Okay? When you come to closing, you have to have proper ID, which is a government issue license, passport, something to that effect to confirm who you are. Just can't be Joe Smo. You got to confirm who you are. It must be photo ID. The money that you bring to the table or to the closing must be certified funds. You can't bring $45,000 in cash to closing.
Not at all.
Not at all. Anything
Okay.
that you do at closing has to be in certified funds. Certified funds is cashier's checks, wire transfers, or certified funds. But you say to me, hey, Richard, cash is cash. Yeah, cash may be cash, but you can't use it to close. You have to have certified funds because that is what's required as far as to verify that the funds. Now, the lender also wants us to certify or get their evidence of what you bought at closing because they have vetted your funds prior to closing. So you can't come to closing with money from Aunt Sally that has not been vetted by the lender. So they want to make sure that that money that you're using for down payment or for closing funds are coming from a account, your account that has been vetted.
With the mortgage, if it's a cash deal, there's no vetting.
If the cash deal is no vetting, it doesn't make a difference where it came from, as long as it's certified funds. Okay.
Correct.
No personal checks. Only certified funds.
Okay.
Last thing, or one of the last topics that I'm going to discuss is that after everything is done, we're going to provide you with copies of your mortgage package. We're going to provide you with a copy of the deed. The deed we are going to record in the county to show that you are the owner of the property. We're also going to record the mortgage with the county to show that the lender has an interest in the property. One thing, buyers, I want you to be aware of, if there is going to be an issue, if you come to closing and say to us that I want to put my wife on the deed, but she's not on the mortgage, that's an issue. Because now you are saying to the lender, they have a party that is in ownership of the property, but they have no liability for the mortgage. If they go into foreclosure, the lender wants to extinguish everybody's interest to the property. Now they have somebody out there who's the owner, but they don't have one on the mortgage, which could be an issue for foreclosure. Could be a foreclosure issue. We're not going to insure that person on the lender's policy because we are ensuring that to the lender that we have guaranteed them or insured them that all parties in ownership are given on the mortgage. So on the lender's policy, we're going to have an exception. And we tell them that up front, we're going to put an exception saying that all parties that are on the deed are not on the mortgage, and you approve that. Therefore, upon your approval, there will not be that party would not be insured in your lender's policy.
So this is okay. I have a question. It's the husband and wife situation.
Yes.
The loan was taken in the husband's name, right?
Right.
So the title, the deed, or that's established with the mortgage is in the husband's name. But because they're husband and wife, so the title would just say Mr. Jones, married man, or something like that? Or
what normally happens when that comes up and we tell the lender that we're not going to insure that that person who's not on the mortgage, the lender will have the spouse sign the mortgage as a non-borrowing spouse, what means that the spouse is on the mortgage, which is the security interest. The note and the mortgage are not the same thing. The note is the promise to pay back the lender. The mortgage is the security for the property. So the non-borrowing spouse is on the mortgage saying that, yes, they are giving their interest to the lender for security reasons, but they are not on the note saying that they are not legally responsible for paying back that obligation to the lender. Note and mortgage are not the same. They are two different things. One is a promise to pay back. One is a security interest. So the way to fix that, you have the wife or the husband, whoever is not on the note, sign the mortgage as a non-borrowing spouse.
Gotcha.
That answer your question?
Yes, that kind of protects them in the event of foreclosure. They're not responsible for the mortgage, but then they lose the house.
Yeah, they're still going to go through that.
Gotcha. Okay. So we're going to wrap up here. You talked about the documents that are needed. You talked about the things that you would require from the buyer and the seller, what to expect at settlement. You covered all of that. Anything else you want to share before you provide your contact information? Like, are there other services that you as a title company provide to people?
One thing that
a specific transaction.
One thing that I didn't mention, title companies normally are not attorneys. So we cannot provide you with legal advice, guidance, or direction. And I think in your sales contract, you have attorney review period, 3-day attorney review. And at closing, you can ask a title, or can't ask us, because I'm not an attorney. Well, what do you think about this? Is this a good deal? Should I go back and renegotiate? Well, we're not attorneys. If you have an issue with the seller, as far as something that the seller took a fixture that was supposed to be there, and you want to do something outside of closing, that's not a title issue. And we can't advise you because we're not attorneys. Very important. If you want legal advice, seek out an attorney. A title company is not an attorneys, and we cannot provide you with legal advice. We do not hold ourselves out to be attorneys, or we do not represent ourselves as being attorneys. Gotcha. Very important. North Jersey, just about every closing that we go to, they have attorneys on both sides. South Jersey, Mercer County and below, you do not have it unless it's a commercial deal or a large transaction.
So not as much in South
Jersey. As much in South Jersey. Okay.
And are there any services that, as a title company, that you provide, outside of, the residential, commercial transactions? Like, I would go to a title company for X, but I'm not buying a property at the time, but other services that you provide?
Well, I'm a title guy. We are title insurance. I don't provide any other service but title insurance. And so somebody can come to us and say that they want to have a deed prepared. I will refer them to one of our attorneys. If they want to have anything else prepared, yeah, we will refer them to one of our attorneys. But I do not provide homeowners insurance, even though I'm licensed to do it. I don't do that. We provide title insurance and closing services. That is what we do for 25 years. That's what we are experts on, and that's what we hold our hat on. I don't do anything else but that, and we're good at what we do.
So please provide your contact information one more time for our viewers, who you are, the name of your company, where you're located, how they can contact you.
Okay. My name, Richard Ransom. I am the owner of Collegiate Title Corporation, or the president and CEO of Collegiate Title Corporation. We're located at 110 Marta Avenue, Suite 107 in Morristown, and 33 Wood Avenue in Island. We're right there at exit 131 off the Garden State Parkway, right at the point where the Turnpike and the Garden State Parkway connect. So we are in North Jersey, South Jersey. If you want our services, we will also visit our website. Orders can be placed online. So anything you need, we can help you with. But like I said, that we are conservative. We're going to make sure that the seller is conveying free and clear title to you. We don't take shortcuts. We are here to service you the right way each and every time.
Awesome. Awesome. Thank you, Mr. Ransom. Really, really appreciate you joining us today. That was a very comprehensive overview of the title process, what title is, and there's a million scenarios. So I appreciate the examples that you gave because I think that those are all helpful to our viewers. I want to thank everyone who watched today. Our guests are really here as a resource to you. So feel free to reach out to Mr. Ransom at Collegiate Title. Remember to like, share, and subscribe to this video if you're watching it live or the replay. And if you want to reach out to our team at Lyonsview Realty, can see our ticker information, but we can be reached at info@lyonsviewrealty.com. If you're interested in a career in real estate, or if you just need more information about the real estate transaction process, you can contact us for a free consultation. I want to thank you again for watching today. Financial Fridays is here to provide you with the resources, information, and tips on trends that impact your bottom line. And I hope that you received something of value today. As always, want to send love, light, and prayers out to anyone who has lost a loved one, to those who have someone in the hospital for whatever reason, for those who are experiencing the impact of the physical distancing. And shout out to all of our essential employees, although a lot of folks now are going back to work, those people who provide the needed services, the healthcare, transportation, food, police, fire, and especially our leadership. I just want to encourage everyone to take care of yourself, to take care of your family, and to stay safe. My name is Clara Lyons-DeVaughn. I'm the broker owner of Lyonsview Realty. We stream Financial Fridays here every Friday on live at 9:30 a.m. Eastern Standard Time on Facebook and YouTube. So you can join us again next Friday. Until then, keep living your best life. Thank you, Mr. Ransom. I appreciate you
Thank
joining us
you.
today.